Okay, I think we will begin. Um, Welcome, everyone. My name is Isra Black. I'm an Associate Professor at UCL Laws, and I'm delighted to be co-chairing this event on the role of health evidence in climate litigation with my colleague Audrey Prost, who is Professor of Global Health at the Institute for Global Health at UCL. I have the privilege of introducing our esteemed panel of speakers today, after which Audrey will offer a few words of comment and chair the Q&A. As this is a webinar, please feel free to type your questions into the Q&A panel as we go along, and we'll come around to them after we've had our panel talks. So before we get going, I'd just like to take the opportunity to say a few thank yous. First, Audrey and I would like to thank our wonderful research assistants and co-authors, Kenta, Tsuda, and Sonora English, for their stellar work on this project. I'll introduce Kenta shortly. Sonora is an honorary research fellow at the UCL Institute for Global Health, as well as consultant in ethics and equity in climate and health at the World Health Organization. The second thing is that we would like gratefully to acknowledge the funding support of UCL's Grand Challenge of Climate Crisis and the UCL Institute for Global Health. Third, we'd like to thank the lawyers who very generously gave their time to take part in the qualitative research interviews Kenta will speak about shortly. Fourth, the thank you to our project steering group for their advice and encouragement. And finally, I'd like to excuse me, I'd like to extend a personal thank you to Audrey for very bravely reaching out across UCL's faculties with the proposal to collaborate. Today's event is partly about showcasing what's possible if people in law and people in health work together. I've learned a tremendous amount from this project, and it's been immensely rewarding, so thank you. Okay, so I'll now introduce our speakers, and I'll introduce them kind of each individually as we go along. So first of all, we have Dr. Kenta Tsuda, who is going to present the research. Dr. Kenta Tsuda is an LSE fellow at LSE Law School, specializing in administrative law and environmental law. His research focuses on theories of lawmaking and litigation. Kenta holds a PhD in law from UCL Faculty of Laws. His thesis examined the place of theories of bureaucratic motivation in administrative law. Prior to his doctoral work, Kenta was a public interest environmental lawyer in Alaska and New England, a corporate lawyer in New York, and a judicial law clerk in Texas. So I'll hand over to you now, Kenta, and I'll also share the screen so that you can give your slides. If you just let me know when to advance.
Great. Thank you, Isra. Thank you, everyone, for joining, and special thanks to Rupert and Sonam for commenting today. Really appreciate it. Today, I'm presenting a project that, as Isra said, was undertaken by a group of legal and public health researchers, including myself, Isra Audrey, and Sonora English. Our project examines how health evidence is used in climate litigation across different jurisdictions. Climate litigation is growing rapidly, but the role of health evidence within it remains somewhat underexplored. Our study asks not simply whether health evidence appears in this litigation, but also how, when, and why lawyers decide to use it. So in my presentation today, I'm going to start with a little bit of background to the project and introduce our research question. I'll then talk about the approach we took to investigate that question. Then I'll turn to what we found and then discuss implications of our findings. Isra, we can go to the next slide now, if you don't mind. Climate litigation has expanded dramatically in recent years. When we speak of climate litigation, what we're talking about is adversarial legal proceedings before judicial or quasi-judicial bodies, meaning essentially courts or something like a court. And in these proceedings, the parties are addressing harms or alleged harms that arise from the effects of climate change. By recent estimates, there are around 3,000 climate change cases that have now been filed globally. At the same time, there's extensive scientific evidence documenting the health impacts of climate change. These include effects such as heat-related harms, respiratory illness, the spread of infectious diseases. Given this strong scientific base, one might expect health evidence to feature prominently in climate change cases. But prior research has suggested otherwise. A US study by McCormick and others found that relatively few cases relied on public health arguments. More recently, Tulin and co-authors Global Review similarly found only small numbers of cases referencing health harms. Going into this study, we still knew relatively little about why this evidence was not showing up frequently in climate litigation, and when it did, how it was being used, and to what effect. Next slide, please, Isra. Our research therefore asked, when and how is health evidence introduced in climate change litigation? And what considerations influence lawyers' decisions to deploy it? To be precise here, by health evidence, we mean factual allegations or evidence concerning the health effects that are causally downstream of climate change. Importantly, we wanted to move beyond simply counting the frequency of this evidence in cases. We also want to focus on how evidence is selected and presented and the lawyer's evidentiary choices behind the use of this evidence in climate change litigation. Next slide, please, Isra. To do that, we used a multi-method approach. First, we undertook a systematic review of climate change cases. We searched the Sabin Center's Global Climate Change Litigation Database, a search that covered cases from 1990 to 2024, focusing outside of the United States in our case. After screening 241 potentially relevant cases, we conducted a full review of 152, and from these we identified 58 cases that used health evidence. For each case, we extracted jurisdiction, the cause of action, the purpose for which the health evidence was used in litigation, the type and source of evidence, and its role in the resulting judicial reasoning. We then conducted qualitative interviews with climate change litigation lawyers. We focused on lawyers involved in the subset of the 58 cases that were resolved at the time of our research, meaning that these cases were no longer pending in the courts at that time. We interviewed 10 lawyers who had been involved in these cases who had used health-related evidence. 70 of these lawyers represented claimants from high-income countries, and 3 represented claimants from middle or low-income countries. The interviews explored why health evidence was used, how it was sourced, and how lawyers thought it influenced litigation outcomes in their case. We combined the case review and interview findings in our analysis. Next is right here. Our data set included 58 cases across 26 jurisdictions. And when we looked at where health evidence appears, several patterns stood out. First, most of these cases were quite recent. Nearly 90% were filed after 2015, reflecting the broader growth in climate change litigation. Second, the cases were brought by a variety of actors. 22 of the cases were brought by individual claimants, meaning private individual claimants. 21 by NGOs, and several were by mixed claimant groups, including both NGOs and individuals. The legal framing of these cases varied. The most common were human rights claims, such as ones asserting violations of the right to health or life, and also prominent were other kinds of other constitutional rights claims. Across these cases, health evidence was typically used to establish standing, to demonstrate harm to the claimants, or to support claims that governments had breached legal duties, for example, procedural ones. Next slide, please. Thanks. From both the case review and interviews, we identified 3 major influences shaping how lawyers chose to use health evidence. I list them here on this slide before going deeper in the following slides. These factors included jurisdictional context, a category that we describe as litigation efficiency, and I'll get into what we mean by that in 2 slides. And finally, lawyers' long view of litigation success. These influences interacted and shaped both whether health evidence was used and what kind of evidence lawyers chose. So I'll briefly discuss each of these in turn. Next slide, please. Climate change cases are filed in many different venues. These include domestic courts, international courts, and quasi-judicial institutions such as human rights treaty bodies. Each of these forums has its distinct procedural rules, evidentiary standards, and at least in lawyers' perceptions, judges varied in the familiarity with which they approach scientific evidence and climate science in particular. Lawyers made decisions about which jurisdiction to file in independently of their decisions about whether and what health evidence to use. These prior independent decisions about jurisdiction were determined by things like who and where who the claimants were, where they lived, and whether applicable laws, including procedural laws, were favorable given the client's harms and the defendant's identity. The choice about jurisdiction shaped the later strategy regarding whether to use health evidence, and if so, what health evidence to use and how. A central challenge that was repeatedly highlighted by lawyers across interviews was the anticipated difficulty of establishing causation. Climate change is cumulative, transboundary, and influenced by many factors. This makes it difficult to connect a defendant's conduct to specific health harms. That difficulty can be increased or decreased based on the applicable procedural rules and evidentiary standards in a case. For this reason, jurisdiction and legal framing strongly shaped the evidentiary strategy. Next slide, please. The second major influence was what we call litigation efficiency. What I mean by that term is that lawyers in these cases, they pursue success in the litigation while at the same time attempting to avoid incurring unnecessary litigation costs. Here, we're using costs in a very broad sense, which would include both direct costs, things like filing fees and running up legal bills, but also costs in terms of time, and importantly, judicial resistance to the claimant's arguments. Litigation is expensive and time-consuming. Lawyers, therefore, aim to present evidence that's credible, accessible to judges, and unlikely to trigger lengthy factual disputes. For this reason, many lawyers relied heavily, for example, on official reports for health evidence, sources such as IPCC assessments, World Health Organization reports, or government publications. These sources offer several advantages in lawyers' eyes. They're widely recognized as authoritative. They're less likely to be contested by defendants, who in many cases contributed to or even authored them. And they present scientific findings in digestible formats for courts. In contrast, relying heavily on peer-reviewed studies or expert testimony could, in lawyers' view, catalyze what's described as battles of experts, which can be very costly and lengthy. And courts may then defer to government defendants or struggle to evaluate conflicting scientific claims. With these litigation efficiency considerations in mind, lawyers therefore often preferred evidence that, in effect, simplified scientific debates rather than presenting it at a very high level of resolution. In some global south jurisdictions, there are additional challenges that would arise. Lawyers described limited availability of health data, lack of government research, or concerns about judicial familiarity with climate science. In these cases, lawyers may have needed to generate evidence independently, sometimes even conducting new data collection themselves. Next slide, please. The third influence is what we call a long view of litigation success. For many lawyers, the goal of climate litigation is not limited to winning a particular case. Instead, litigation can serve broader purposes, such as shaping public discourse, influencing future legal arguments, or increasing political pressure for climate action. In these contexts, lawyers see health evidence playing an important role that transcends its effect in the particular litigation. Climate change can often seem abstract. Health evidence makes it personal and tangible. It helps tell stories that communicate climate change's impacts on human lives and relatable experiences. Many cases are accompanied by public campaigns, media engagement, or policy advocacy. So even if a case or the use of health evidence in it does not produce immediate policy change, it may expand legal possibilities, educate courts and the public, and build momentum for future litigation or policy change. Lawyers' choices about the use of health evidence were made with this context in mind in many situations. Next slide, please. These findings suggest several broader implications. I list them here on this slide, and now I'll talk about them in turn. So we can go to the next slide, Isra. Health evidence is used within judicial or quasi-judicial contexts where it's governed by more than the relevance and reliability of research and data. So that gives us a first takeaway here, the centrality of litigation strategy in considerations of how to use health evidence and where to do so. Lawyers must consider judicial capacity to interpret complex science, the costs of expert evidence, the risk of prolonged evidentiary disputes, and there's always another side that's looking to make litigation costly and difficult, including by casting doubt upon evidential questions. Choices about whether to use health evidence, and if so, how, are made in this constrained strategic context. That may not be obvious to the health researcher viewing this from the outside, who, for example, has presented studies that are directly on point and might wonder why this is not showing up in the courtroom. Our studies suggest that there's some benefit in stepping into the lawyer's shoes to understand why they make the choices that they make regarding the presentation of health evidence. Next slide, please. The second implication is that there's a need for better health data. Many lawyers rely on international reports such as those from the IPCC, but in some circumstances, especially where lawyers are addressing harms in global south contexts, these reports can lack local data and population-specific health impacts. These gaps can make it difficult to demonstrate individual harms, disproportionate vulnerability, or geographically specific effects. So improving access to localized health data and research could therefore strengthen climate litigation in those situations. Next slide, please. Third, and relatedly, our research points to the potential for stronger collaboration between legal and health communities. Effective use of health evidence requires dialogue between lawyers who understand procedural constraints and the evidentiary rules in which information is going to be presented in litigation, and health researchers who have produced the underlying scientific research itself. Such collaboration could help to translate research into legally usable evidence, anticipate protracted factual disputes between experts, or more concretely, potential judicial resistance to information, and improve the clarity of expert testimony and the presentation of this information in a litigation context. Next slide, please. Thanks. What I hope you take away from this presentation today is that the role of health evidence in climate litigation cannot be understood simply by counting how often it appears. Instead, its use is shaped by jurisdictional context, lawyers' consideration of what we described as litigation efficiency, strategic considerations, and lawyers' visions of the long-term impact of the litigation they're undertaking and the presentation of health evidence within it. Lawyers operate in very different legal and institutional environments with varying access to data and expertise, and understanding these contexts is crucial for strengthening the contribution of health evidence to climate governance through litigation. Thank you.
That's wonderful, Kenta. Thank you very much for that very clear and informative presentation of the research findings from our project. I now have the pleasure of introducing our first discussant, who is Dr. Rupert Stuart-Smith. Dr. Stuart-Smith is the Deputy Director and Senior Research Fellow in Climate Science and the Law at the Oxford Sustainable Law Programme at the University of Oxford. Rupert's research advances methods in attribution science to shed new light on the impacts of climate change on health, glaciers, and extreme weather events. He studies how climate science can be leveraged to enhance legal scrutiny of corporate and state climate action and accountability for the impacts of greenhouse gas emissions. Rupert also publishes on the implications of burgeoning climate litigation on climate-related financial risk. Rupert, we're really pleased that you were able to join us this afternoon, and I'll pass to you now. Thank you.
Wonderful. Well, thank you very much, Isra, for the kind introduction. And Kenta, a great pleasure to follow your presentation. Obviously, in the course of Kenta's remarks, we heard about some of the ways in which health research is and indeed is not being used in the context of climate litigation. I'd like to spend a bit of time reflecting on what the nature of that health research is, and in particular, how the field of scientific inquiry has developed over the last decade. Towards the end of my remarks, I'll, I'll enjoy thinking together with you about the potential uses that developments in health attribution work might have in future climate-related cases. You will all be aware that the types of things that occur as a result of climate change, like extreme weather events and other potential climate-related drivers of health impacts, are not entirely novel phenomena on the whole. Storms, droughts, floods, heat waves, they all would have happened in the absence of climate change. But with developments in scientific research, we can assess the extent to which climate change has made these events more extreme when they do occur, more intense when they do occur. This field of climate science, known as climate change attribution, which has developed over the last 20, 25 years or so, had at the first, in its first years, allowed us to make statements about the effect to which climate change was affecting individual heat waves or the strength of individual storms. But in the last decades, we've seen important developments within this field that allow us to go beyond those meteorological events themselves. No longer do we need to stop at quantifying just how much hotter climate change has made a heat wave. Now we can also speak in many settings about the effects that climate change has on health too. Health impact attribution is what this development in climate change attribution science has been called. And it allows us to quantify for a wide variety of potential climate change impacts, just what climate change impacts have been occurring on health. Some of the first studies of this focused in particular on heat-related mortality. To a great extent, this is the easiest of the health impacts of climate change to evaluate. Our climate models work extremely well for quantifying climate change effects on heat, including on extreme heat events, and the relationships in epidemiological terms between temperature and mortality are clear-cut and well reported in the literature. In 2021, one of the most significant studies in this area was published. A team led by Ana Cabrera, professor at the University of Bern, found that around 37% of heat-related deaths in the locations they studied, 700 or so locations around the world, 37% of heat-related deaths was now attributable to human influence on the climate. Since then, a number of studies have been done that have extended these methods beyond the impacts of climate change on heat and mortality alone. Studies have assessed impacts of climate change on malaria, on dengue fever, on fire-related air pollution mortality, temperature-sensitive multiple sclerosis symptoms, and more. So our understanding of how climate change is affecting health around the world is increasing broad across different types of health impacts and is growing. Of course, these impacts that I've named remain a small portion of the overall impacts of climate change. But what we have is a set of methods now that can be deployed to great effect in a wide variety of settings where data permits, that could provide information relevant to adjudicating climate-related claims, where claims are made that greenhouse gas emissions are in some way affecting health. When you put together the existing set of studies that have been done, and this was a key finding of a paper led by Colin Carlson, published in Nature Climate Change last year, over 30,000 climate change attributable deaths are already occurring annually. And this is just from this very small portion of the total impacts of climate change that have been assessed to date. But in parallel with these developments in climate change, impact attribution includes assessing the health impacts of climate change, as well as economic or agricultural impacts of climate change. At the other end of the causal chain, the relationship between emissions of greenhouse gases from individual entities, potential defendants in these claims, and global climate change has strengthened as well. In the last few years, a number of particularly important studies have been published that demonstrate that it is possible to quantify the contribution made by individual emitters of greenhouse gases, individual companies or individual countries, to global climate change, but also to the impacts of climate change, the intensity of heat waves, or to economic losses caused by climate change. The consequence of this is that we have an increasingly clear scientific understanding of the causal chain between greenhouse gas emissions and, right the way down the other end of it, their impacts on health or on the economy. And this allows us to make scientific statements about the relationships between these emissions and their impacts that could play an increasingly important role in court. We've heard from Kenta some examples of how research of this type can inform a range of legal claims, and indeed in some jurisdictions is already doing so. But we know that health evidence can be used in a wide variety of ways. In a piece published in the British Medical Journal last year, Guy Elisi and I explained how increased understanding of the health consequences of climate change could allow for growth in climate-related legal action grounded in those kinds of health evidence that could mirror the successes of legal action that has challenged state action in the face of environmental pollution, among other examples, and could compel states to uphold their legal obligations with respect to protecting health. And to some extent, we see this already happening. Take, for example, the Klima Signorinien case that was decided by the European Court of Human Rights a couple of years ago. In that case, to establish the applicant association's victim status, the court had to demonstrate that, or had to establish that climate change was causing and continuing to cause deaths, especially to the group to which the applicants belonged. They were elderly women. And in doing so, the court cited evidence on how climate change is intensifying heat waves in Switzerland, the location where the applicants live, and the result of that was an increased risk of death. So we've already seen in studies how developments in attribution science can be used to demonstrate these links between greenhouse gas emissions and potential consequences or risks to individual claimants. But attribution science and the associated methods can go a little further than that too. In the Klima Signorinien case, adaptation was also an important consideration. One might reasonably respond, well, just because a group of elderly Swiss women are put at increased risk of heat-related deaths as a result of the greenhouse gas emissions of a country like Switzerland, is it a better solution for Switzerland to cut their greenhouse gas emissions, or instead just to implement meaningful adaptation measures? And in this context, the court again referred to scientific evidence that looked at the potential impacts that adaptation in the Swiss context had had. The court concluded that although the applicants could agree that adaptation was also crucial, it was not an answer to what Switzerland should have done to mitigate climate change. And to get there, they cited scientific evidence that we'd led in our group here at Oxford that found that adaptation in the Swiss context over the last few decades had indeed reduced heat-related mortality, but that in spite of that effect, the number of heat-related deaths was still going up. In other words, the effects of climate change were outweighing any effects of adaptation brought to date. Scientific evidence plays an important role across climate-related lawsuits, and with developments in health attribution over the last few years, it is plausible that health-related claims, certainly they would be better supported than ever they had been before, and it's plausible that a growing number of health-related claims could be brought on the basis of these scientific developments. This development in scientific evidence, it gives us a number of things. Firstly, it demonstrates how factual claims made in climate-related cases can closely parallel non-climate cases. The methods used in health attribution are pretty much the self-same methods that have been used and widely cited in environmental litigation with histories that go back decades. These statistical epidemiological relationships between meteorological hazards and health impacts, well, it's the same epidemiological methods to a great extent as is used in many other settings. And this should open up opportunities for climate-related claims to follow in the footsteps of successful past litigation on health impacts of environmental pollution. In a world of growing climate change impacts, and in a world in which we're rapidly approaching and will soon exceed 1.5 degrees above pre-industrial levels, scientific evidence that assesses the impacts of climate change could provide new routes to justice for affected communities. Scientific research can assess not only the impacts of climate change that are occurring to date, but allow us to assess what impacts of climate change we expect to see in the decades to come, depending on choices we make now. We can assess the potential impacts of adaptation to reduce future health burdens, as well as the consequences of following emission reduction pathways in which we limit warming as aggressively as we possibly can. At this point, that would be to a peak warming of around 1.7 degrees above pre-industrial levels, or the consequences of higher emission pathways with higher levels of warming and their associated consequences for health around the world. Scientific evidence, therefore, provides both a backward-looking and a forward-looking understanding of what greenhouse gas emissions mean for health around the world. As I mentioned, the scientific methods we have at our disposal put us in a better and better place to understand just how climate change is affecting health in a growing number of locations around the world and from a growing number of pathways. We can ask questions that are legally relevant, and in so doing, we can provide information that is of support to judges confronted with resolving climate-related claims relating to the health impacts of greenhouse gas emissions. With that, I'll conclude my opening remarks, but I'll be very happy to take any questions on the scientific side of things in due course. Thank you.
Thank you so much, Rupert. It's now my great pleasure to welcome Dr. Sonam Gordhan. I should say actually that it's a pleasure to welcome back virtually Sonam and Kenta to UCL. They're both PhD students, PhD graduates from our faculty. Dr. Sonam Gordhan is a lecturer in environmental law and a member of the Centre for Climate Law and Governance at the Dickson Poon School of Law, King's College, London. Sonam researches and teaches in the field of environmental law with a particular focus on climate change and adjudicative process. Sonam completed her PhD at UCL Laws, exploring the relationship between adjudicative method and climate change problems. Sonam's research examined fundamental precepts of common law adjudication and the role they play in climate change legal disputes. Sonam, over to you. Thank you very much.
Thank you so much, Isra, and thank you, Audrey and Isra, for inviting me to be a part of this discussion. It's been fantastic to hear from Kenta and Rupert so far. I think this is a fabulous paper, and it lays the foundation for a fruitful future discussion of the relationship between health evidence and litigation going forward. I'm going to start with a quote from the paper itself, which is that lawyers often made decisions about the use of health evidence. These choices were informed by precedents, evidentiary rules, and venues' approaches to reviewing facts. The jurisdiction influenced which facts to allege and upon which sources to draw. Some lawyers perceived domestic courts as better equipped to handle complex, particularized health evidence. I take that starting point because my focus today will be on how do we think about this issue from the perspective of courts and the judiciary. So as a domestic common lawyer, these matters of jurisdiction and legal process are the crux of any discussion about how health evidence can be integrated into environmental litigation. And that's because these questions of jurisdiction are fundamental to any understanding of how courts engage with complex information in their process of resolving disputes, whether it's a human rights dispute about an environmental problem or more generally in relation to climate change litigation. So if we want to argue for better or more effective engagement with health evidence in climate litigation, we really have to take seriously and reflect on the particular nature of the process of courts when reasoning disputes. Now, with all of that in mind, I'm going to reflect on the implications of the paper for the reality of environmental litigation in the English context. And in particular, I'm going to walk through the case of Richards and Environment Agency, which was a case decided by the Court of Appeal in February 2022. Now, we're yet to see a climate change case relating to human health impacts in the domestic context, and historically, litigation relating to human health risks has raised significant questions of procedure and competence, as Kenta has highlighted. And so the case of Richards is a really helpful window into what we might expect in the domestic sphere. And Richards in particular is a reminder that this difficulty of overcoming matters of procedure and competence aren't likely to go away. So starting then with the basics of the case before working through some of the issues that Richards raises for thinking about health evidence in domestic environmental litigation. Matthew Richards was at the heart of this case, and he is a vulnerable child who suffers from chronic respiratory diseases, and he was repeatedly exposed to hydrogen sulfide in the early years of his life. He lived less than a kilometre from Wally's Quarry landfill site, which held a landfill permit from the Environment Agency, which is the national regulator of landfill sites. And between 2019 and 2021, numerous residents in the area complained to the agency concerning a foul smell emanating from the site caused by excess emissions of hydrogen sulfide. Now, Matthew suffered from bronchopulmonary dysplasia, a respiratory condition which he developed when born prematurely. And during the first 3 years of his life, he suffered persistent respiratory problems, which were exacerbated by poor air quality. And due to his condition, he is more likely to develop COPD, which is a life-limiting condition. Now, the central claim brought by Matthew was that the Environment Agency, which was responsible for regulating the landfill site, was in breach of its obligations owed to Matthew under Articles 2 and 8 of the European Convention on Human Rights, primarily due to its failure to exercise due diligence and its poor regulatory oversight of the quarry. At first instance, in the High Court, the judge found that the agency's management of the site did not fulfil the obligations of the European Convention on Human Rights. And according to the judge, the effects of hydrogen sulfide on Matthew's health, and in particular, the heightened risk of him developing COPD, meant that the trigger for Articles 2 and 8 had been met. And he issued a declaration requiring the agency to implement advice from Public Health England, which is the executive agency responsible at the time for protection from public health hazards. Public Health in England no longer exists. However, this judgment was subsequently overturned by the Court of Appeal, which was primarily concerned with the limits of the role of the court in such a case. And Lord Justice Lewis, who wrote the leading judgment, he said at the outset of his judgment that the case concerns the proper approach to be taken by a court to allegations that an environmental regulator, in this case, the Environment Agency, is acting in a way which is incompatible with European Convention rights. And so he recognised that there was no dispute as to whether Matthew's Article 2 and Article 8 rights were affected. It was plain for him that the evidence presented to the court did not demonstrate a breach of the obligations on the Environment Agency. So it was held that the judge in the lower court had erred in granting the declaration, which was neither justified nor required to remedy any unlawful act or failure to act. Now, health evidence was central to Matthew's claim in respect of his Article 2 and 8 rights. And the first instance judgment, the lower court judgment, was a really impressive tour de force of the relevant WHO guidelines, public health risk assessments produced by Public Health England, as well as expert witness statements from Matthew's paediatrician and an epidemiologist. And in fact, there had been no dispute about whether Matthew's human rights were engaged, as I said. The more central and fundamental question was whether the public body had failed to protect these rights in their management of the site, that public body being the Environment Agency. So taking all of this, I'm going to turn to three forms of complexity that this case raises for thinking about the role of evidence in climate litigation, drawing on the Richards case: epistemic complexity, institutional complexity, and legal complexity. So epistemic complexity. A core question in Matthew's case was the matter of the relationship between the level of hydrogen sulfide in the air, the agency's action to limit pollution levels, and the resulting implications on Matthew's respiratory health. Now, there's no neat story of this relationship. There are different standards around the world as to how much exposure to hydrogen sulfide is safe exposure. There's an information gap in relation to the effects of long-term exposure to hydrogen sulfide. And while there is epidemiological evidence that hydrogen sulfide can be harmful to communities, there are no definitive studies pointing to specific instances of harm like Matthew's. And this complexity led to what is referred to in the paper and by Kenta earlier as the battle of experts issue. There was a dispute over whether Matthew, as a particularly vulnerable child, was only likely to develop COPD because of his premature birth, or because of the prolonged exposure to hydrogen sulfide. Now, his pediatrician thought there was no good, reliable safety level. He advocated for a zero tolerance approach. In contrast, for the defendants, an epidemiological expert saw it that any development of COPD in Matthew would be squarely the consequence of Matthew's premature birth, and no exposure to hydrogen sulfide could be a factor. Now, what's key for our purposes is that it's important to remember that it isn't the job of the High Court or the Court of Appeal to make a determination as to which evidence was correct. They don't have the capacity to do this. Moreover, establishing a past or a current breach in the context where a harm is yet to materialize, as was the case for Matthew, he hadn't yet contracted COPD, it raises a conundrum for any domestic court that's tasked with reviewing the actions of a competent authority like the Environment Agency. So in the context of Matthew's case, this was not a case of looking backwards at a dispute that had arisen, at a harm that had occurred, in order to determine a breach of the Environment Agency's obligations, but rather it was to determine a current or existing breach, which is not impossible, but it raises the bar of difficulty for a domestic court, particularly in the English jurisdiction, which leads to the second form of complexity, institutional complexity. So, as I've said, this is really about the relationship between the court and the Environment Agency and how their competences interact. So, a landfill quarry site is required to comply with the requirements of Directive 1999 on the landfill of waste, which is implemented into England through the environmental permitting regulations. And as a regulated facility, operations at the site are prohibited unless authorised by an environmental permit. And the Environment Agency has the function of granting or varying the permit, revoking a permit, enforcing a permit, suspending a permit. It's the agency's exercise of judgment that is of primary importance. So determining whether a permit is contravened or whether there's a risk of serious pollution is fundamentally governed by whether the regulator considers this to be the case. And this is really critical institutional context for understanding the role of the court and in turn how health evidence might be integrated into litigation. Because this was a judicial review of an expert executive agency. The court could not jump in and prescribe the standards that the Environment Agency ought to accept, and nor was it the court's task to determine what exactly should have been done in the present situation to reduce pollution in a more efficient way. All the court could do was assess whether the regulator approached their scrutiny and their management of the site with due diligence and in accordance with their obligations under the human rights framework. Which leads to the third and final form of complexity, which is the legal complexity. It's easy to see a case like Richard's as an example of judicial conservatism or a failure to protect Matthew's human rights. That might be true, it might not be true, but it's important not to ignore that legal complexity that lies underneath it. The case is first and foremost a judicial review of executive decision-making, and it raises fundamental questions about what it means for the agency to do its work with due diligence and what it means for a court to scrutinise that standard within the boundaries of its legitimacy. And navigating these boundaries requires careful and thoughtful reflection on the nature and scope of a court's jurisdiction, as well as a regulator's capacity to do its job well. I'm going to sum up very quickly because I'm almost out of time. Well, why does any of this matter for health evidence in climate litigation? Well, what it tells us is that there is rightly a significant amount of hope, particularly after decisions like Klimas and Urinen, that the European Convention on Human Rights can offer a mode of redress for claimants suffering human health impacts from climate change. And what I've tried to show today is that realising those rights will require an understanding of domestic norms and procedures, and that these procedures can pose significant challenges. And the second and final reason is that this is important is that while all of this does sound a bit pessimistic, it is a fundamental starting point for any argument about how courts might need to evolve, how they should engage with health evidence. In other words, in order to imagine what courts should do, we need to start with what they can do. And Richard's and other cases like it are a window into that story and what it is. It's a story of epistemic, institutional, and legal complexity. Thank you very much.
Thank you, Sonam, for that wonderful talk. Audrey, I'll pass over to you for a few comments, and then also just to remind participants to offer questions if they would like to ask them, although I'm sure we can muster some ourselves.
Thank you so much, Isra, and thank you so much, Dr. Tsuda, Dr. Stuart-Smith, and Dr. Gordhan. I've learned a huge amount from you prior and during these presentations, so really appreciate your contributions. Before we go into a bit of a Q&A session, I'll just share a brief reflection drawing upon the study that Kenta described and on your contributions today. I came to this work very much as a global health scientist, a public health scientist, acutely aware of the harmful health impacts of climate change, largely thanks to the work of the wider scientific community, the Lancet Countdown on health and climate change, and lots of civil society-led research and action. And for people like me and many others in the scientific community, the huge frustration with the slow pace of climate action on the part of many governments and corporations makes it very attractive for us to think of climate litigation, to borrow Isra's phrase, as a kind of big stick with which to spur action and seek redress from governments and corporates. And this enthusiasm is further fueled by the exciting attribution science developments that Rupert described to us earlier on. And that makes us all think that we can forensically attribute health harms to emitters or to lack of action framed as negligence, especially if we begin to consider vulnerable population subgroups, for example, children, as in the case that Sonam referred to, or the elderly, as in the case of Clinia Seniorinen, or indigenous groups, as was the case for some of the lawyers that we interviewed as part of this study. What I've learned and what I take away from this work and the considerations that Sonam outlined is that in order for the stick to work, it needs to be carefully, collaboratively crafted as a collaboration between health and legal practitioners so that the stick is fit for context and for purpose. So we all maximize the opportunity both for winning the case on legal grounds, but also for the public engagement that litigation affords. And I think we're very encouraged by the fact that more and more cases are making use of health evidence and trying different strategies for this. We've all talked about Clima Seniorinen today, and I think that was a very exciting examples of that. The reason why I got particularly excited by Clima Seniorinen is because the court in Switzerland recognized standing for non-profit associations in climate change litigation, which allowed them to act on behalf of individuals, even when those individuals do not meet the court's personal victim status requirements. So that means that civil society organizations that represent a vulnerable group of claimants that we can also identify epidemiologically, especially in countries where we have fine-grained public health data and hospital records, we can really do a lot to demonstrate health harms for these vulnerable groups, as Rupert described for us. So this is all very encouraging, but I think Kenta and Sonam provide a very important word of caution about the need to collaboratively craft the stick together. So that was my remark, and let's turn to some questions in the chat, or perhaps I'll ask you an opening question about vulnerable groups specifically. We're getting a lot of cases that are focused on vulnerable individuals or vulnerable groups. And I wondered whether you felt, Rupert, that we currently sufficiently have the granularity of data to support these kinds of cases, or whether this is essentially not the most helpful strategy to take.
Well, thank you. Thank you for that question. It's difficult to answer in the abstract, to be honest, but I think there are certainly examples where we can actually say quite a lot. Let me give you one. One case pending before the European Court of Human Rights at the moment is the case of Molnar versus Austria, And the gentleman who brought the case, he has Mutov's syndrome, temperature-sensitive multiple sclerosis. So he is a vulnerable individual, and has particular sensitivity to the impacts of heat. Progressively higher temperatures, his ability to do ordinary everyday activities is substantially curtailed. At about 30 degrees centigrade, he can become temporarily paralyzed. And scientifically, we can now address issues like that. In a study which is currently available as a preprint led by one of my students, we looked precisely at this problem of climate change impacts on multiple sclerosis symptoms in Austria, and we found that, yes, indeed, we could see substantial impacts of climate change on increasing impacts on this particular group of people. But that might not be the case for all vulnerable groups in different parts of the world. Data limitations are a serious concern. And we often hear references to data limitations, so I thought perhaps I might share a brief reflection to provide a bit of context in terms of why this can be such an issue. If you're going to develop epidemiological relationships between some climate variable like temperature and some health outcome like mortality, you need to have good data of both to develop a statistical model that allows you to essentially predict mortality based on the temperatures that you have. In the case of heat-related mortality, for hundreds of cities around the world, it's possible to get data of daily numbers of deaths, and we have the data of what the temperature was on those same days. Because we have those two lines of information, you can use sophisticated epidemiological models to derive these so-called exposure response associations between the two. The problem is we don't have that data everywhere in the world, and critically, the relationship between temperature and mortality differs substantially from place to place. So you can't just guess what that relationship will be elsewhere. You can do slightly more sophisticated things where you try to predict what that relationship is elsewhere, but it becomes much more difficult to validate your results if you're doing something like that. So I think the answer is yes, but yes, there are very good examples of vulnerabilities that are compounded by climate change impacts that constitute good bases for legal claims, especially in settings where it's important to demonstrate that the claimant is not just affected by climate change in a manner that's consistent with the population as a whole, but that they are particularly affected by climate change. But that is not the same as saying that it's possible to demonstrate in all settings in a quantitative way how climate change is affecting vulnerable people.
Thank you, Rupert. Kenta and Sonam, I wonder whether you would like to add anything to this on the focus on vulnerable groups in particular within climate litigation.
A very quick addition, a quick comment is that often if you're thinking about a litigation strategy, it's very easy to establish the hook, to establish your victim status if you are a member of a vulnerable population. So going back to Richards, I mean, Matthew Richards was demonstrably a vulnerable child, but there were population-wide issues with the emanations from the landfill site. But it couldn't have been that local residents who weren't suffering over and above an ordinary level of suffering could bring the same claim that Matthew could. So from a legal perspective, it really is it's the hook, it's the way in.
Thank you, Sonam. I'll encourage participants who are here to post their questions using the Q&A handle if they'd like. And in the meantime, I'll ask a very difficult follow-up question about possible reasons why so many of the claims that we looked at, of the cases that we looked at in our study, Kenta, were against governments or public bodies rather than corporations. I'm not an expert in this, but as environmental lawyers, is this a pattern that you expected to see? Is there a particular reason why these cases are not being brought against carbon majors or other carbon emitters, for example, in the private sector?
Oh, sorry, Audrey, are you asking me or is this for everyone?
I think I'm asking you and Sonam as our
Okay.
environmental law experts.
Yeah, well, I can start, and then Sonam, you should jump in and as well. I think that probably there are a couple of reasons. My sense is like I think that maybe in a sense it's building off of what Sonam was describing earlier and these different constraints and what courts can do in litigation. Also, I think this would be our first kind of influence that we identified in our study, Audrey. Namely that in certain jurisdictions, I think that the kind of claim that you can bring against a public authority in something like what Sonam's describing, without not necessarily exactly the kind of judicial review in the UK context, it might be easier to establish liability. You don't need to go through the full causal showing, even if it's the case that perhaps that's becoming easier. Lawyers have different views on that in our interviews, but all in some cases it might just be sufficient to show that the government hasn't considered something that's very material and important, and that might be easy. That might be strategically easier for lawyers to do, not least because it's also less costly. There's less likely to kind of precipitate one of these battle of experts in a very protracted, expensive litigation. And then I think this is kind of just applying the factors that I described in the presentation from our study, Audrey. I think there's also the kind of rhetorical or communicative aspect to litigation against public authority. It's very salient, probably in some cases, to litigate against a government and publicize this view, which is relevant for policy matters, that a government actor or public authority is acting insufficiently. So I think there are probably all kinds of reasons mapping onto the kind of stuff we found.
Thank you,
Yeah.
Kent.
Oh,
Sonam, I think we have a minute or so if you want to add something.
very, very quickly, two points to add on to what Kent has said. Firstly, is that the vast majority of environmental law, speaking in the domestic context, is public law. So we're thinking about obligations on the state to enforce or implement environmental law. So again, coming back to Richard's, the landfill site is a private operator, but Matthew could not have brought a case against the landfill site. It was against the Environment Agency that failed to or that he alleged had failed to fulfill their obligations. Secondly, I think, again, in the domestic context, standing is a huge factor in deciding who you're able to bring an action against and what kind of action you can bring. In the English context, standing is very generous, so it's very easy to establish that you have an interest in a matter to bring a case. In public law disputes, whereas in private law disputes, you generally have to display or demonstrate some kind of physical harm or harm to your property, which is incredibly difficult for particularly vulnerable groups.
That makes sense. Thank you both for answering a very basic question that I know a lot of public health people have, so that's really helpful. We're at time, so that leaves me to thank our participants and all of you on the panel and Dr. Isra Black for joining us today. We'll post the recording online at UCL and share it with participants as well as the results from the study when it's published. Thank you very much, everyone.
Thank you.
Thank you.
Thank you.